My name is Ryan Helgeson. I'm with McEntee Law Group, and today we're going to be talking about the H-1B cap registration season that is upon us. First, a little bit of legal disclaimer, as you would expect from a lawyer. This presentation is for general informational purposes only. It is not legal advice, so please contact an attorney or an accredited representative for individual advice. The timelines and estimates that I'm going to state here are subject to change and depending on the U.S. government's workload and the specific facts of each case. So keep that in mind as we move through. A general outline of what we'll be covering. First, I'll give you a general overview of what the H-1B cap process is. We'll talk through the lottery registration process. We'll discuss some changes that are new for this year and also give some reminders on changes that happened last year as well that impacted the process. I'll talk through the USCIS online system, the filing of the H-1B petition if you are selected in the lottery, and then some options if unfortunately you are not selected. And then finally, we'll have some time for questions and answers at the end. So the overview of the H-1B. H-1B is a non-immigrant visa, meaning it's temporary. It's a category that allows employers to petition for professionals that are going to be working in a specialty occupation. A specialty occupation is a position that requires at least a U.S. bachelor's degree or its equivalent in a directly related field. I want to break that down a little bit more just to kind of get into the nuances of that. So when I say U.S. bachelor's degree or its equivalent, that means it can be a foreign degree that is the equivalent of a U.S. bachelor's degree. In those cases, it requires an independent evaluation to ensure that they are equivalent. So sometimes, depending on the country you're from, a 3-year degree will be listed as a bachelor's, but it may not be equivalent to a U.S. bachelor's degree. Some are, depending on the country's educational system. Equivalency can also include a combination of education and experience. Again, with an independent evaluation, you can make the determination of whether or not the education you have and or your experience is equivalent to a U.S. bachelor's degree. The general rule for H-1Bs is that 3 years of experience equals 1 year of college education. So if you don't have anything post high school, you would need 12 years of experience in the field to show that you have the equivalent of a U.S. bachelor's degree. And then you can do the math as you have certain years of college. It removes the lessons the experience required. Another thing that's new this year is the language directly related field. That came about in January this year. At the end of the Biden administration, they issued a final rule that made some modifications to the regulations regarding H-1Bs, and the directly related language was a big part of that. It's intended to increase flexibility for the employers and the employees. So it allows for a range of fields that will qualify for a position. It doesn't have to be one specific degree type. You can have a range of degrees that will match the required position. Additionally, it focuses on skills, not necessarily the title of the degree. So they're looking more for what your classes were in, what your experience is as far as what you've learned and how it relates to the job, not necessarily your degree title. So you can look more for instead of having a degree in computer science, you can look for somebody with experience in machine learning and artificial intelligence. You can be more specific, and it allows for more flexibility to match the degree you have to the position that's being sought. So there's really two parts to an H-1B specialty occupation. The employer has to require a bachelor's degree or its equivalent for the position, and then the beneficiary has to have that education or experience in a directly related field. a couple of definitions, which I've already been throwing around, so might as well get to those. The petitioner or registrant, that's the sponsoring U.S. company. So that's the company that is filing the H-1B petition and creating the H-1B registration. The beneficiary is the foreign national or non-citizen that has the U.S. degree or equivalent. That's the person on whose behalf the petition is being filed. I would note that the beneficiary does not have to be currently working for the petitioner to register or file an H-1B petition. Neither does the beneficiary have to be in the United States for the registration or the filing of the petition. The cap itself, there are a limited number of H-1Bs available every year. 85,000 are set aside. Of those, 20,000 are provided for individuals with a master's degree from a U.S. institution, and then an additional 65,000 for those with at least the bachelor's degree or its equivalent. It's a very oversubscribed visa. Generally, in the past few years, we've seen 300 to 400,000 applications for the 85,000 visas available. So over the last decade or so, there's been a lottery that's conducted to determine who gets to file a petition with USCIS. The selection process is random. It is truly random. There is no way to game the system. A lot of people always ask, how do I get better odds? You can't, beyond having a U.S. master's degree, which I'll explain in a second. The 20,000 for the U.S. master's cap are selected first through the lottery process, and then individuals with U.S. masters that aren't selected in the master's cap are then placed in the other pool to select the 65,000 remaining visas. So they have a slightly better chance of being picked. There's kind of two chances there. So in general, what we've seen recently, there's kind of a 1 in 4 chance of being selected if you have a U.S. master's cap, maybe a 1 in 5 chance if you have a bachelor's degree or equivalent. Obviously, that's dependent upon how many petitions or how many registrations are filed each year, and that's difficult to predict, but that's what we've seen recently. Regarding the master's degree, you don't have to have it at the time you are registered, but you must have completed the master's degree before the petition is filed. So that's, if you're in your final semester of your master's program at a U.S. institution, you're going to graduate in May, you can still register under the U.S. master's cap, and then once you complete your program, the petition can be filed on your behalf under the U.S. master's cap. So you can take advantage of it even if you are close but haven't quite completed your degree. There can be additional rounds of selection. USCIS will generally select maybe 90 to 95,000 overall, with the understanding that there's going to be some denials. Some people are not going to file the petition even though they're selected. And if they don't issue all 85,000 visas, they'll conduct another random selection process to kind of to fill out that number. That generally occurs in August or September of each year, and it's for a very limited number. So when the selection process occurs at the end of March, USCIS sends out emails notifying you of selection. They don't notify you if you're not selected, because you can still be included in that potential second or even third round of the lottery. So there's still a chance, but it's very, very minimal if you're not selected in the first round. And then finally, the last note here is that prior to 2020, you had to file a complete H-1B petition to be part of the selection process. In 2020, they moved to an online registration system, which has greatly streamlined everything and was an excellent advancement. And that's what we're working with now. Some recent changes to the online registration. There are organizational accounts. This was put into place last year. So this allows a company to manage all its registrations, through one single account on myuscis.com or .gov. The registration is based upon the beneficiary, and I'll go into all of these in a little more detail. The filing and registration fees have increased. The filing fees increased last year, but I'll remind you of those numbers. And then the registration fees are going up this year. New for this year is there's a longer cap gap extension, which I'll explain. And then finally, beneficiaries with a controlling interest in the company may file an H-1B petition through that company. The last two are part of that recent the amendment to the regulations that the Biden administration put in place. So the organizational account, this allows online collaboration within a group. So each company can have an account with several members. It allows the H-1B process to be fully electronic. The registration must occur online, and then you're able to file an H-1B petition online as well. Note that you cannot file H-4 applications for dependents electronically. So the process there is you either, if selected, the H-1B can be filed online, you'll get a receipt notice immediately, and then you can file the H-4 on a physical hard copy, or you can file both via hard copy with USCIS, whichever works better. The online process allows the company and the legal team to link their accounts so that basically there's email notifications that go back and forth that let you know each step is being completed and processed, and it allows for a very streamlined communication system to complete the registration process and the filing if you choose to do that online. And within each company account, you can have several members. You can have administrators. You should have at least 2 administrators. And then you can have several other members that have more limited access. That they won't be able to make changes, but they can check on progress and access the system and keep that going. So it's a vast improvement over how it used to be, and they're making modifications gradually that have been improving the system. So it's been a very welcome change. The selection process used to be based on each registration. So if there was a company that has multiple entities, different FEINs, but they're essentially all related companies, they could file an H-1B petition for a single individual under each company. So if they had 15 entities, they would put 15 entries in, and that person would have 15 chances to be selected. USCIS caught on to this process, decided to put an end to it last year, and they switched so that now the selection is based upon an individual beneficiary. So no matter how many registrations a particular beneficiary has from how many different companies, that beneficiary can only file one H-1B petition. So this improves the odds for everybody. It makes the system more fair, particularly for smaller employers that don't have these multiple FEINs that and different entities. So if the beneficiary has more than one registration with different companies, if that beneficiary is selected, the employee, the beneficiary, kind of has to choose which one they're going to file. If more than one company files for that person, the first one to be approved is the one they work for. Everything else would be denied. So you may not necessarily know as an employer if your employee has other companies filing for them, but it's something to keep in mind, as you go through the process. That's a pretty rare occurrence, but it is something to be aware of. One of the biggest changes this year that came out with the new regulations is for those with a controlling interest in the company that will be filing the H-1B. So if you have a controlling interest in a company, you're a startup entrepreneur, you founded a company, you own more than 50% of it, that company can act as the petitioner for you as the beneficiary. So they can register you for the H-1B and file the petition on your behalf. A controlling interest is defined as more than 50% ownership or a majority of the voting rights. The distinction here is that under a regular H-1B, where there's not a controlling interest, the H-1B is valid for 3 years initially and can be renewed for another 3 years for a total of 6 years. Under this controlling interest process, the initial validity period is limited to 18 months, and then you can get one 18-month extension. So essentially, it's half the time that you would have under another H-1B, where you don't have a controlling interest. The rules did not anticipate a situation where, if 2 years and 11 months in of having a controlling interest, you divest yourself of some of that interest and you go below 50%. We don't know whether or not you'd be eligible for another 3 years and 1 month of H-1B status. It's unclear, but as time goes on, we'll figure out how that'll play out. But for now, you can assume that if you have a controlling interest, you're limited to 3 years. If you don't, it's a 6-year limit. The filing fees, as I mentioned, went up last year. The fraud prevention and detection fee, the education and training fee, the filing fees, and then premium processing, those all were raised last year as part of the process. Generally, if you're not using premium processing and you have more than 25 employees, filing the petition costs $2,780 in government filing fees, non-inclusive of attorney's fees. And if you have fewer than 25 employees or 25 or fewer, the cost will be $1,710. If you want to use premium processing, that's an additional $2,805. As a reminder, premium processing changed from calendar days to business days at the same time. So it's so instead of 15 calendar days, it's now 15 business days. So more around 3 weeks instead of 2 weeks. This year, the online registration fee was increased. In previous years, it's been $10. It's now $215. So that starts this year. So it's not a prohibitive cost, but it is a substantial increase over what they have been charging. I don't think it's enough to actually affect the number of people that apply, because it is still a fairly nominal amount, but that remains to be seen, I guess, whether or not there's a difference in how many people apply, and if that increased fee is any sort of factor. The registration this year begins on noon Eastern, 9 a.m. Pacific on March 7th, which is Friday, and runs through noon Eastern, 9 a.m. Pacific on March 24th, which is a Monday. If you want to have a chance to be selected in the lottery, you have to register within that period. There are no exceptions. Registering early does not give you any sort of advantage. It just has to be within that period, and you're put into the pool for selection. Employers will need to include the foreign passport information of the beneficiary. So that's part of the documentation we'd collect to complete the registration. All the registration occurs through the organizational accounts. The company is in charge of, final sign-off on everything. If they're working with an attorney or a legal team, then there's back and forth there to finalize the registration. New this year, USCIS indicated that the passport must not be expired at the time of registration. Last year, they allowed for expired passports to be entered as long as you filed with a valid passport when you, if selected, and filed the petition. There are some exceptions to this, but it's unclear exactly how they'll play out logistically. So if you're a stateless individual or from a country such as Venezuela, where you're frequently unable to renew your passport, there are some exceptions to this, but in general, the passport must be valid this year. So if you're thinking about if your employees are going to be registered for the lottery, or you're an employee that is going to be registered, if you know your passport is expiring or is expired, now is the time to get on top of that so you can have a valid passport for that registration period, which starts in just a few weeks. The registration closes on March 24th, as I said. Generally, near the end of March, between the 29th and 31st, USCIS will conduct the random selection process, and then notifications will go out via email to those that are selected. Both the company and the legal team will be notified of that selection. The filing period, if you're selected, is 90 days. So it runs from April 1st through June 30th. Within that time is when, you have to file the petition with USCIS in order to take advantage of your selection. If you're approved, the job begins on October 1st, or can start no sooner than October 1st of this year. And now we'll move on to what happens if you are selected, which hopefully you all are, despite the odds. The filing process itself, is basically putting together all of the paperwork for the petition. There's several USCIS forms that are listed here that cover all of the details of the position and attorney representation. There's the LCA, the labor must be certified. It takes 7 days to be certified, and that must be included with the H-1B. You have to include your selection notification or confirmation. That confirmation notice will say where you file, which service center, and it will also indicate which cap you were selected under, whether it's master's cap or the regular cap. That's important because if you were selected under the master's cap, you must submit proof of your U.S. master's degree at the time that it's valid at the time you file the petition. As I mentioned before, you have to include educational documentation to show that you're qualified for the position. The evaluation I mentioned earlier, whether it's for a foreign degree or combination of education experience. You'll submit your passport, maintenance of status documents. The new rules really stressed maintenance of status as part of their focus to ensure that there are legitimate H-1Bs being filed. So, you want to make sure you submit all of your Form I-20s. If you're an F1 status, you have pay statements from your time in OPT or STEM OPT. You really want to document that fully with the initial petition because they'll be looking at that very closely. And we also include information about the company, whether that's promotional brochures or website printouts or information like that, and then the filing fees, as I discussed. That kind of makes up the petition that's filed. A lot of individuals that are registered for the H-1B process are currently on OPT or STEM OPT as part of their F1 student visa status. So CAP-GAP is a process that allows for an automatic extension of your employment authorization while the H-1B petition is pending. So the requirements for this, you must have properly maintained your F1 status throughout your whole time as a student. Your employment is subject to the H-1B cap, so you've been selected in the lottery. Your employer has filed the petition as a change of status rather than consular notification. So change of status means you can switch from F1 to H-1B within the United States. Consular notification would require you to travel abroad to get the visa stamp and re-enter before you can begin work in the H-1B status. Your employment authorization document, whether OPT or STEM OPT, expires between April 1st and September 30th. And then the H-1B petition was filed before your employment authorization expired. So if your employment authorization expires in April of this year and you're selected in the lottery, the petition has to be filed before that expiration date in order for your employment authorization to be extended under this CAP-GAP protection. So it needs to be, promptly filed. That's something to be very much aware of. If the petition is not filed before that, you're not eligible for CAP-GAP, and you would have to exit the United States and then re-enter on the H-1B visa if or when it was approved. New for this year, they extended the amount of time that CAP-GAP can run for. It used to be that it would automatically extend through September 30th, with the idea that H-1B petitions would begin on October 1st. Now the automatic extension runs through April 1st of the following year, so April 1st, 2026, if necessary. That allows for those that are selected in the second or third round, if there are those selection processes, and if there's requests for evidence that delay the adjudication, this allows you to keep working and eliminates potential gaps in employment authorization while that H-1B is extending. So it's it also becomes less necessary to file premium processing upgrades with USCIS. So it's a very welcome change that addresses some of the logistical challenges that occur with slow processing times at USCIS. If you're selected, there are travel considerations. A lot of people are going home, either after they graduate or at different times for different reasons. So the registration and selection in the lottery does not affect your travel, but if you are filing the petition or your employer is filing the petition as a change of status, you need to be physically present in the United States when that is filed. So you can't be, so if you have travel planned in, April or May, the legal team or your employer would wait to file the H-1B petition until you had returned and are back in the United States. If your H-1B petition has been approved and your F1 status or OPT remains valid under its original expiration date, you can travel and re-enter the United States before October 1st. And then on October 1st, assuming that's the start date of the H-1B, your status would automatically change to H-1B. If you travel during the CAP-GAP period, so if your H-1B or your OPT EAD has expired under that original period, and your H-1B, whether approved or not, you would lose the benefit of the CAP-GAP protection. So you'd have to re-enter on H-1B status after approval and obtaining an H-1B visa stamp through a U.S. consulate abroad. So if your original date of employment authorization has expired, we recommend that you do not travel outside the United States, as you can be, stuck waiting until you're able to re-enter under the H-1B. You can re-enter as early as 10 days before the start date. So if the start date generally will be October 1st, 2025, you can come into the United States on September 21st, 2025. But you're not permitted to begin work until October 1st under the H-1B. If you are one of the many unlucky ones that are not selected, there are some options for you to consider for how to maintain your status in the United States or remain in the United States. If you have employment authorization that remains valid through the next registration period, then you can try again. There's no limit on the number of times you can be entered in the lottery to be selected, so you can always keep going for it. If your employment authorization is expired and you don't have options to get a STEM OPT extension, or you're at the end of your STEM OPT, there is what's called Day 1 CPT. That's curricular practical training. Some educational institutions, mostly under master's or doctorate programs, will offer what's called Day 1 CPT. So that allows you to get credit for working. So you can kind of maintain your employment as soon as you begin the program. You can keep working for your employer as long as it's related to the degree program you're in. A lot of institutions will have a 6 or 2 semester delay before you can get CPT, but there are those out there that offer that curricular practical training on day 1 of the program. If you're looking in this situation, you really want to be certain that the institution you're enrolling in is legitimate. So you want to do your research, make sure it's a certified university with a good reputation, that you're not going to be stuck arguing that you really were enrolled in a real school and weren't stuck in some sort of fraudulent endeavor. So you want to do your research before you enroll in the Day 1 CPT. Additionally, there are organizations that are exempt from the lottery system, which I've just spent a long time explaining. Those are universities or institutions of higher education, nonprofits that are associated with those institutions of higher education, nonprofit research organizations, and government research organizations. So those institutions, if you have a job with them, they can apply for an H-1B at any time of the year. They're not subject to going through the lottery system. There's no registration. There's no the calendar of filing in March and starting in October doesn't apply. They can file for that H-1B any time of the year, and you can start for them as soon as it's approved, regardless of the date. But finally, you could explore other non-immigration statuses, to see if you're eligible for those, such as an L1. If you're working for a multinational company, you may be able to transfer abroad for a year and then come back in under an L1. An E2, if you're entrepreneurial and your country qualifies under that. It's an investor visa, so you could look at starting your own business in the U.S. If you have extraordinary ability, the O1 visa is a possibility. Additionally, the TN would be a possibility if you're from Canada or Mexico. It's not a direct path to a green card like the H-1B is. So the H-1B may have some benefits over the TN, but the TN could be a very good option. And there's also an E3 if you're from Australia. That would be preferred to the H-1B. So if for some reason you're Australian and you ended up in the H-1B lottery and weren't selected, the E3 would be the way to go. And it should have, would be the preferred option anyways, because there is an annual limit, but it's never met. So that's, it's a very similar process as far as the H-1B and similar requirements with the specialty occupation and everything, but it's a very good option if you're Australian. So those are the main things you can do if you're not selected. So that covers everything I have. Do we have any questions? I'm trying to find those. There we go. One moment. There's one question here about you have a pending reply from USCIS on a different application, and whether or not the university can apply for an H-1B for that candidate. In general, you can have as many irons in the fire as possible to try to get status. If you have one petition pending and you file for additional or a different type of status, that will generally nullify the original petition. So depending on the status you're seeking, switching to an H-1B could possibly end that previous authorization, or lead to denial of that pending petition. But the H-1B would be a possibility, if the university or the employer is willing to do that. There's another question here about what's required to register, whether or not you can self-sponsor for the H-1B. The answer is no. An employer has to serve as the petitioner. So you have to have a job offer from an employer to pursue the H-1B. The alternative there is if you have that controlling interest. So if you start your own company, essentially you can act as your own petitioner. Obviously, that's a major undertaking and not something that happens quickly or easily. But if that's the case, that's kind of how a version of self-petitioning. Otherwise, you'll have to have a job offer from an employer, and they will have to be the ones to register for you. Regarding the conversion of educational qualifications, there are lots of information out there about what is equivalent between countries. In general, most bachelor's degrees from European and South American countries, and China, Japan, most countries overall, I guess I've covered most of the world there, are going to be equivalent to a U.S. bachelor's degree. The real consideration is whether or not there's a 3-year program, and if that's going to qualify. So a lot of programs in India are 3 years. That won't be the equivalent of a U.S. bachelor's degree. So you'll have to complete a 4-year degree or have an additional 3 years of experience to kind of make up that gap there. Regarding the cap exempt, so if a university or another cap exempt institution is applying for an H-1B, the processing time, if you're using premium processing, you can get that response within 15 business days. That initial response can be either an approval or a request for additional evidence. If additional evidence is requested, USCIS will have another 15 business days to make the adjudication after the response is received. In general, I would say processing times are 1 to 3 months. Once it's filed using premium processing. Without premium processing, it can take more in the range of 3 to 6 months. And if a request for evidence is issued, you can add a couple months onto that as well. Are there any other questions? Yeah, here's one more actually that came in regarding H-1B that getting an H-1B even if you don't have OPT. It's not necessary for you to be on OPT to apply for the H-1B. You don't have to be in the U.S. You don't have to be working for the company that is sponsoring you or is registering for you. That's just the usual path, which is why I talked so much about it. It can be, a prospective employment under the H-1B. So I think that covers all of the questions. As you can see on your screen, we're all over social media. We are wherever you are, so please follow us and check out our other posts. We do have a First Friday presentation coming up on March 7th with our managing partner, Ray McEntee. So if you want to sure check that out, he'll cover recent happenings in immigration law, which there are many going on right now. And I thank you very much for your time and your participation. Everyone have a great day.